Judge, the video, I'll just summarize by saying it's like a Wild West shootout in broad daylight in the apartment complex. I would have served it on you back on.
Yeah.
I have it in my email.
It's been a little bit.
It's been a while, yeah, because I filed the motion a while ago.
December 17th is
Okay.
my certificate of service.
All right, so are you Jonah Johnson?
Yes, ma'am.
And Mr. Johnson is charged in cause number 25 DCCR 1775 with aggravated assault with a deadly weapon. And Ms. Holmes has filed a motion asking that Mr. Johnson's bond be reduced. It's currently set at $300,000. And then there's also 2 misdemeanors that he has as well. And those bonds, it looks like, are $3,000 and $5,000, which we're not discussing, but just that he has the charges also, in addition to aggravated assault with a deadly weapon, to misdemeanor charge of unlawful carrying a weapon, 2 cases of unlawful carrying a weapon. And so Mr. Coleman filed a response, obviously in opposition to that. Ms. Holmes, Mr. Johnson, best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, thank you. You can put your hand down. You may proceed, Ms. Holmes.
Thank you. Mr. Johnson, how long have you been incarcerated at Jefferson County Jail?
2 months.
Okay, and in that 2-month span, your bond has been set at $300,000, is that correct?
Yes, ma'am.
And has your family tried their best to secure or try to get you bonded out at that amount, have been unsuccessful?
Yes, ma'am.
Okay, now, prior to this, was your bond originally at a different amount, and was it raised at some point?
Yes, ma'am.
Okay, and do you have any property or anything that you could possibly sell to secure where the current bond amount is?
No.
Okay, does your family have any type of assets or property that could secure at this amount?
No.
Okay, are you requesting that the judge lower the bond to give you an opportunity to bond out, and whatever stipulations the court may have, whether it's a GPS tracker or home confinement, would you be willing to abide by those restrictions?
Yes, ma'am.
And where would you be residing if you were able to bond out?
I'm on the side.
Okay, and where is that, in Beaumont?
Yes, ma'am.
Okay, and your mom is here today, correct?
Yes, ma'am.
Okay, and she would be able to let the judge know that that's where you would be residing?
Yes, ma'am.
Okay, and since you've been incarcerated at the Jefferson County Jail, have you received any write-ups?
No.
Okay. At this time, I'll pass the witness, Your Honor.
Any questions for the defendant, Judge? Just argument, please.
Okay, so just for the record, I'm taking judicial notice of the court's file. It does include an affidavit of surety surrender. That's where the bond got increased, because the bond's been filed, that affidavit, because it reads that the defendant failed to pay for his GPS device. It had not been charged at that point, so this, it says since 11/7 of 25, and this was filed November 19th, so it hadn't been charged for a couple of weeks, it looks like. They further stated that he will not respond to their attempt to reach him, and he cannot be located. Therefore, they felt like their bond was at risk, and that's why they filed that affidavit to get off the bond, which was granted, and that's why that was raised. Give me just a second. I also want to take a look at the probable cause affidavit, just so that I can have an idea of what we're talking about.
When you're
Mr.
done with
Hall?
that probable cause affidavit, I'd like to offer, for the limited purposes of this hearing, the surveillance video from the apartment complex of the incident.
Okay, thank you. Any objection for this hearing?
No objection.
I'll take a look at it. Give me just a second when I take a look at this. Mr. Coleman, I'm ready.
Before I show the court the video, I just want to highlight in my reply, the defendant's he has 9 prior arrests, 2 of which were for unlawfully carrying a weapon. Those cases were pending when he committed the instant offense. Judge, the video, I'll just summarize by saying it's like a Wild West shootout in broad daylight in the apartment complex. Here's the video there. You can just hit play there. Of course.
Has, and what about Kendrick O'Veal? Is he charged as well?
I don't think he got charged.
He was the other shooter,
Yeah,
according to
he would
the
be the person in the video
PC.
there in the front. They're saying at the front of that red truck. My understanding is that it's the defendant here who's in the background wearing the dark cluttered clothing.
Okay.
And the bystander who is shot, you'll see her behind like that white van.
Okay.
Because I think the young lady got charged with tampering. I think the one that got shot got charged with tampering. O-V-E. Kendrick.
In that video, it also appears that the first shot, and it's obviously not the best angle, but anyway. The motion's denied. You can go back with the bailiff. It's crazy. Insane. Nope, you need to go back with the bailiff.
Thank you.
So, Mr. Armenta, I make notes and go through the pre-sentence reports, obviously before court. I use a highlighter to highlight convictions and things, and usually the prettier it looks, the worse it is. With highlighting, yours does not look good. Good morning, you're Norberto Armenta. Is making this a second-degree felony offense for punishment purposes. And there was an agreement of a cap of 12 years and to dismiss the evading as part of that plea agreement. I've received the pre-sentence report as well as a whole packet that the defense provided that has certificates and different things that I have reviewed. Has everyone had an opportunity to review the pre-sentence report as well as those other documents?
Yes, Your Honor.
I have.
Are there any additions or corrections?
No, ma'am. No, ma'am. No, Your Honor.
All right, Mr. Kimler, you may proceed.
Well, Your Honor, we start, as usual, with the criminal history, which is rather extensive, Mr. Armenta. I will say I've spoken to him at the jail extensively and reviewed the case. And this is really an unusual fact situation in that he's the one that called 911 on himself in the vehicle because he was having I thought, and I'll let him explain it to you what the reasons that he did call and concerns. And as a result of that, received the DWI. The evading detention, Mr. Armenta, is from Harris County and has had some bad experiences with law enforcement. I think there was a low speed failure to stop. They did deploy the spike strip and he ultimately came to a stop. And he related to me that he was in fear, I guess, of law enforcement and wanted to get to a spot where he would feel safe pulling over, and that's what he did. But I'll let him elaborate as to his thinking on that.
Well, but what you're thinking is on that really isn't going to matter. You were on cocaine and Xanax at a minimum that day, so your thinking was not clear because you were under the influence of a lot of things in driving.
That's
So,
correct,
okay.
Your Honor. And I think that, he relapsed, I would say, because He has indicated, and I guess enough factually demonstrated that he is trying to maintain his sobriety through religious, faith-based rehab, or I'll say programming, but efforts to maintain his sobriety. And the certificates that have been provided to the court were obtained by him while he was in custody in Harris County Jail, awaiting transfer over here. He does have a motion to revoke probation in Harris County for a DWI that will be resolved after this case is disposed of. In the VSI, again, relating to criminal history, there's some self-reporting that Mr. Armento did as far as gang affiliations. I want the court to know too that these were self-reported by Mr. Armento. He didn't have to inform the probation officer. These are things that he told the probation officer in good faith about his history because he wanted to be honest about things. It certainly doesn't make him look good or any better, but it was important to him that he be honest about that. We're not asking for probation on this. It's a 12-year cap, and I think Mr. Armento really is in a better position than I am to give the court an indication of where he is in his life as far as his recovery, what his plans are, what his efforts have been. So I would defer to him at this point, talk to the judge and let her know where you are.
Did she get my college?
Yes, and he also, yes, there's some paperwork. He was in San Jacinto College, I think.
Right.
Yes, ma'am. Good morning. My whole life, I've been a criminal all my whole life. 2015, I began to change my life. I gave myself to God, and I mean, there's not much I can say, but I never, ever since I started doing recovery and trying to change my life, I had difficulties, and I was doing good, and I relapsed. And Your Honor, I never dialed 911, and what they're teaching us is to take responsibility for your actions, and and that's one thing that I wanted to do is I wanted help, and I wanted to get locked up for a while and take classes, and that's what I've done before, and that's the only way I knew how to get help. And I apologize to the courtroom for my mistakes that I've made, but I've never called 911 on myself, and I feel like that's a big step as well. As doesn't make it any better, but I wasn't asking for probation, 2 years, 3 years, 4 years. I asked for 5 because I felt like, I don't know if that was a good punishment for me, but I felt like I needed to get away for a while from the wrong that I did, my mistakes, and I'll take full responsibility for my actions. And I'm sorry for what I caused. But I do have a daughter, and she's asking for me, and I'm just trying to better myself for her. And I never thought that changing my life would have to deal with me being an addict, and that's what I'm dealing with now.
Thank you.
Sorry.
Thank you. Ms. Malfino?
Judge, obviously, his criminal history dictates that somewhere in the range of 10 to 12 years would be appropriate for him and would have been a sentence that was mitigated by the cap. I do appreciate his honesty. It's not what we typically hear from a defendant. Usually it's the excuses. I appreciate that he's not even asking for probation and insulting the court that way, so I'm deferring to what he thinks is best.
So, Mr. Armenta, I make notes and go through the pre-sentence reports. Obviously, before court, I use a highlighter to highlight convictions and things, and usually the prettier it looks, the worse it is. With highlighting, yours does not look good. Your criminal history, like you said, is ridiculous. I appreciate what you're trying to do now. Obviously, it's a little late or a lot late, but it's Ms. Malfino's right. People don't take responsibility. I had a note on here for pretty much what she said, that 10 to 12 was probably the right thing to do. I think I'm inclined to give some something for what you are trying to do, but 5 years is not going to be it.
Yes, ma'am.
So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. And at this time, find you guilty of driving while intoxicated, third or more. Find those prior offense true. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. Good luck to you, sir. Hopefully you'll continue doing what you have been.
And there it is, a life caught between choices, consequences, and second chances. In this courtroom, the weight of past mistakes met the fragile hope of redemption. 2 months behind bars, a family pleading, and a man facing the reality of his actions, all unfolding under the steady eyes of justice. It's a stark reminder, every decision echoes, every moment counts, and the path to change is never easy. So, what would you do if the scales were yours?